No? The title is Judicial Docility. What I'm trying to suggest here is the court, instead of being, instead of assuming its role as a stronger check on executive and legislative powers, has refused to do so. And I'm trying to do that with a bunch of, or rather, a few cases that will illustrate my point. Okay. My thesis is that judicial deference to the president is making a stronger chief executive and frustrating constitutional design. That is not the goal of the framers of the 1987 Constitution. And to prevent executive dominance, the present Constitution strengthened the judiciary by, among other things, putting limits on the use of the political question doctrine. It broadens the scope of judicial inquiry into areas which the court, under previous constitutions, would have normally left to the political departments to decide. So the political question doctrine, according to the Supreme Court, is no longer the insurmountable obstacle to the exercise of judicial power or the impenetrable shield that protects executive and legislative actions from judicial inquiry or review. That is what we teach you, and it's not true. Recent Supreme Court decisions challenge this premise. The court has been consistently ruling in favor of the executive branch, and to justify these decisions, the court has decided not to address certain issues and, in effect, has been creating new political questions. I address three instances when the court has declined to enforce constitutional provisions, and these are Article 6, Section 26, Paragraph 2, on the President's certification to the necessity of the immediate enactment of a law to meet a public calamity or emergency. Right? We are bypassing the normal legislative process. Second, Article 7, Section 12, on whether the President shall inform the public on the state of his health. And third, Article 7, Section 18, on the President's power to declare martial law. Okay. Judicial power under the 1987 Constitution, and you know this, I have students from last semester who were, I guess, brainwashed into coming here. The 1987 Constitution was adopted during the third wave of democracy. That is the period of constitution writing that peaked in the late 1980s, and we are right smack in the middle of it. And during this time, a lot of publics and peoples replaced their authoritarian regimes with more democratic ones. We couldn't fit the bill any more than that, right? Because that was the time that we ousted a dictatorship and installed a more democratic government. The framers of the 1987 Constitution addressed, or rather expanded the definition of judicial power by providing, and we all know this from the second paragraph of the definition of judicial power. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights, which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of government. It is that second sentence that is the innovation, and it is meant to do away with or to minimize the impact of the political question doctrine. So under the present Constitution, we have what we call the expanded mode of judicial review. Okay? And this one arose from the use and abuse of the political question doctrine during the martial law era under former President Ferdinand E. Marcos. And if you can see my footnotes, I am actually referring to Supreme Court decisions, and it's not fake news. It's not fake news. The past may have been bleak, said the Supreme Court. Nonetheless, the Supreme Court's expanded scope of judicial power shaped the landscape of the Philippine judiciary, ensured the potency of the power of judicial review to curb grave abuse of discretion by any branch or instrumentality of the government. That means the court can now look into what is traditionally regarded as a discretionary act on the part of the political branches of government. Para bang bar review, you're ready. You're supposed to think, alam ko na yan. That's how you know you're ready for the bar. Okay, as a result, and then I'm repeating, the political question doctrine is no longer the insurmountable obstacle to the exercise of judicial power or the impenetrable shield that protects executive and legislative actions from judicial inquiry or review. So we have created a stronger judiciary that should not be afraid to check this time whether, even if it is a discretionary act, whether you abused your discretion in performing that act. Political questions. What's a political question? I hope I'm not going too fast. Political questions are, and this is from the Tañada versus Cuenca definition, those questions which, under the Constitution, are to be decided by the people in their sovereign capacity, or in regard to which full discretionary authority has been delegated to the legislature or executive branch of the government. It is concerned with issues dependent upon the wisdom and not legality of a particular measure. So the Supreme Court will not review questions as to the wisdom of a law. That's within the discretion of Congress. Although I never thought I would say wisdom and Congress in one sentence. I surprised myself. So, as intimated earlier, the 1987 Constitution has narrowed the reach of the political question doctrine, quote, to a great degree, close quote, when it expanded the scope of judicial review. Okay, but this is the important part. The concept of political question, however, never precludes judicial review when the act of a constitutional organ infringes upon a fundamental individual or collective right. And to be clear about it, where there is a serious allegation that the legislature acted beyond the scope of its powers and enacted a law which contravenes the Constitution, it not only becomes a right but a duty for the court to declare the law unconstitutional. By the same token, when an act of the president is seriously alleged to have infringed the Constitution and the laws, settling the dispute becomes the duty and the responsibility of the courts, which is what I tell my students, that if you want the Supreme Court to hear your case, you have to point to a specific provision of the Constitution and allege that the political actors or the other branches of government are violating that provision. It becomes difficult, therefore, for the court to say no, because according to them, it becomes their duty to review, to exercise their power of judicial review. As long as you can point to a provision, 99.9% of the time, 99.8% of the time, they will take on your case. Whether you win in the end or not, it's something else. So, what are the cases that we are talking about? So according to, so we know from the first semester that there are 3 readings before you are able to enact a law. The exception, of course, is except when the president certifies to the necessity of its immediate enactment to meet a public calamity or emergency. Okay? And there have been cases, of course, before when the litigants are trying to or alleging that the president exercised his power without meeting the constitutional standard, the standards, right? There has to be a public calamity or an emergency. And yet, bills are being certified by the president left and right. For instance, let's read the second paragraph of Article 6, Section 26. No bill passed by either house shall become a law unless it has passed 3 readings on separate days, and printed copies thereof in its final form have been distributed to its members 3 days before its passage, except when the president certifies to the necessity of its immediate enactment to meet a public calamity or emergency. And that's what I mean, and that's what all the litigants are trying to point out, that there has been no calamity or emergency that would justify the use of that exception. But in as early as, the case of Tolentino versus Secretary of Finance, this is where the court starts to show that it really would rather not decide on whether the president abused his or her discretion. As early as 1994, the court deferred to Congress's response to the president's certification as a basis for dismissing these challenges. In Tolentino versus Secretary of Finance, the court pointed to the Senate's acquiescence to restrain itself from reviewing the president's action. Said the quote, "It is noteworthy that no member of the Senate saw fit to controvert the reality of the factual basis of the certification. To the contrary, by passing Senate Bill number 1630 on second and third readings on March 24, 1994, before you were born." Tama? God, I was just joking. Talaga? Man. The Senate accepted the president's certification. Should such certification be now reviewed by this court, especially when no evidence has been shown that because of the bill was taken up on second and third readings on the same day, the members of the Senate were deprived of the time needed for the study of a vital piece of legislation? Okay, next, Aba Kida versus Senate of the Philippines, where the Supreme Court said the House of Representatives and the Senate, in the exercise of their legislative discretion, gave full recognition to the President's certification and promptly enacted RA number 101, 5-3. And under the circumstances, nothing short of grave abuse of discretion on the part of the two houses of Congress can justify our intrusion into our power of judicial review. And I have a problem with that because I thought we were trying to examine abuse of discretion on the part of the president. Isn't that what the exception was about? And for some reason, the court says, well, you didn't show me any abuse of discretion on the part of the two houses of Congress. The other disturbing thing is, apparently, it doesn't matter if there is abuse of discretion as long as Congress acts on that certification. So together, everyone, all these players have nullified that that the course to judicial review. Because if the branches of government decides, okay, let's enact that law, then that prevents the Supreme Court from exercising judicial review. And that's the problem, right? Because the issue is, let us say, for example, what is the emergency in the case of the enactment of the 2024 budget? Even budgets are being certified as urgent. And and then I know the Supreme Court is going to say, well, they enacted the budget, so we may not believe that there's an urgency or there's an emergency, but the fact that they acted on it means they agreed. So it no longer depends on the court's examination of the grounds for a speedier enactment of a law. It doesn't depend on that. It depends now on whether Congress decides we're going to act on this measure or not. And if you don't think there's something wrong with that, there's something wrong with you or your first semester professors. Oh, no, I'm just kidding. You can't blame them. Diba? Okay, let's go to Calleja. I think for a second here, I thought the Supreme Court got it right. The Supreme Court has one reason that you can cite so that it will review the President's certification: grave abuse of discretion. However, the court still defers to the President when examining the presence of grave abuse of discretion. In other words, I thought the determination of the grave abuse of discretion was a function of the court. It was their grave abuse of discretion. But apparently, as such, the court must, sorry. So the court went on to say, in this case, President Rodrigo Duterte, through a letter dated June 1, 2020, certified the necessity for the immediate enactment of HB number 6875 to address the urgent need to strengthen the law on anti-terrorism and effectively contain the menace of terrorist acts for the preservation of national security and the promotion of general welfare. So as the court sees it, there is no grave abuse in determining that the passage of law to sufficiently address terrorism in the country falls within the public emergency exception. So ganun yun. It's that, well, that one is a clear case naman, I think, right? When the president says terrorists are invading the country or causing havoc, then it's pretty easy to say that there was no grave abuse of discretion on the part of the president. And that's what I meant earlier by, I think the Supreme Court finally got it right, that what it should be doing is examining whether the president acted with grave abuse of discretion, not the other houses of Congress. Now, the Supreme Court has also been very lenient when it comes to cases involving the enactment of the budget because of the role played by the president in government. So in Lawyers Against Monopoly and Poverty versus Secretary of Budget, the court said, in the chief executive dwell the powers to run government. Placed upon him is the power to recommend the budget necessary for the operation of the government, which implies that he has the necessary authority to evaluate and determine the structure that each government agency in the executive department would need to operate in the most economical and efficient manner. And in, that's Pichay. And in LAMP, the court elsewhere has said that from the regulation of fund releases, the implementation of payment schedules, and up to an actual spending of the funds specified in the law, the executive takes the wheel. So lots of discretion on the part of the executive branch. I hope not too much, because we are in the Supreme Court right now questioning the DOF's decision to transfer your money. Actually, that case doesn't fall under those broad definitions that I just read to you. So, but that's the problem with the case of legislation. Apparently, the court will not examine abuse of discretion if either house believes that there was, and they act on your law. So that's my way of saying I think we have reintroduced the political question doctrine, because it is now up to the other branches of government to decide instead of the Supreme Court deciding that there was a violation of the Constitution.